Hello, everyone. Welcome back to another episode of the Divorce Differently podcast. This is another episode in our series of divorce talks with Irwin Mitchell. Today, we're talking about a situation that causes a lot of anxiety when cohabitating relationships end. You've shared a home, you've contributed in all sorts of ways, but your name might just not be on the deeds. And that raises the question of what rights do you actually have? So unlike married couples, cohabitants in England and Wales don't have the same automatic financial claims, and that gap between what feels fair and what the law recognizes can be really unsettling. Many people worry about whether they can stay in the home, whether they're entitled to anything that they helped to build, and especially what happens if the property is sold. So in this episode, we're going to break down those worries, and we're going to look at what kind of protections and claims they may still have available when they separate after cohabitation. To talk about this, I've invited Richard Shaw. Richard is a senior associate in the London family team at Irwin Mitchell, and he has extensive experience across the full spectrum of family law, including pre- and post-nuptial agreements, cohabitation disputes, divorce, civil partnerships, and complex financial remedies. Richard, it's wonderful to have you here today. Thank you for joining me.
It's a pleasure.
So this is really a question that I certainly hear a lot from clients, and I'm sure you hear on a daily basis, but this concern that, if you haven't been married and your financial claims are not embedded in the law, do you have any claim to the house if your name isn't on the deeds? And do you have any rights at all?
Well, I'm going to give you a typical lawyer's answer, which is you might do. It depends. But and unfortunately, that's often the way that the law is, and certainly in the family field, everything is often so fact specific that you often have to dig down quite a long way into finding out the exact facts and exactly what's going on within the relationship to then establish whether there might be any claims and what steps that you might be able to do. But I think one of the important things just to talk about very quickly is that there are still a lot of people out there who think that there is this idea of a common law marriage that just arises because you've been together with somebody for a period of time, and there really isn't. That doesn't exist under the law in England and Wales. And unfortunately, the only real rights that you have in relation to property or financial provision or anything like that arise through either co-owning some form of property together, or if you have children together. And we're going to talk about the former rather than the latter today, I think.
Yes. Yeah, we're talking more about the finances for sure. But, it's true that there is a specific angle with the children that potentially raises opportunities for more claims. But for those who haven't had children together, does it really matter whose name is on it? Or would, for example, a judge look at who contributed what at the start to purchase the home or later on during the relationship?
Yes. So in some cases, the court will look at financial or even other wider contributions to a property. But any kind of rights or claims that you might have in relation to a property that you don't have your name on the title to really stem from often from a common intention that's expressed between the cohabitants that somebody should have an interest in that. And this all really stems from the sort of the slightly complex way that the English courts look at the ownership of property. Basically, because when we talk about is your name on the deeds, what we're really talking about is your name on the title to the property at the land registry.
Yes, absolutely.
And what that goes to is the legal ownership of a property. And actually, the bit that we often actually end up talking about and disputing about is what we call the beneficial interest or the beneficial title to the property, which is if that property is ever sold in the future, who gets what from that money. And I sort of think about this or try and explain this to people because it's quite an odd concept, really. But I try and give the sort of the analogy of a treasure chest. Because you have a treasure chest. It's all sort of different shapes and sizes. One might be very, very pretty. One might be sort of very old and crusty and been buried at the bottom of on the beach or something like that. Now, if you think about the treasure chest itself, that's like your legal title. but it's what it contains: the treasure, the gold, the silver, the jewels. That's actually the beneficial interest, because that's the bit that
Okay.
actually people are arguing about. And when we talk about beneficial interest, not only is it who gets what money if there's ever a dispute about the property, but it
Yeah.
also gives rise to various rights and obligations in relation to that property. So
Yeah.
when you were mentioning earlier about that rights to stay within a property or to
Hmm.
occupy a property, a
Yeah.
lot of actually stems from whether you have that beneficial interest.
Okay.
Okay.
And so how do you establish that beneficial interest?
So the easiest way and the best way is to be a co-owner of the property from the get-go, and so you're
Yeah.
effectively recorded on purchase.
Hmm.
Now, what has happened over the years is that traditionally everybody had been working along the lines that if you were committed and within a relationship, you'd get married.
Yeah.
Now that's fallen away dramatically over the
Absolutely.
years. Since 2014, there's been a rise of over a million people in cohabiting relationships.
Yeah.
There's been a decline of nearly 10% in marriages since in the marriage rate since 2022. And
Yeah.
so the law, which was very much set up to you're together and we'll provide lots of protection for you because you're married, doesn't
Hmm.
really apply. And so you fall back
Yeah.
on these ideas of land law and in particular trust law.
Yeah.
And the way that you can look to establish a beneficial interest in a
Yeah.
property is by way of trust law in the first instance. And it's
Okay.
this concept called a common intention constructive trust.
Okay. That's a mouthful.
It really is. It really is. So I'll break it down for you.
Yeah.
So the common intention bit is you're in a relationship and you're living in a property together, and
Yeah.
maybe your name isn't on the title, but you have some discussions with your other half,
Hmm.
and you talk about the fact that actually you both do intend you to have an interest in the property. You might not be on the title, but actually at the end of the day, you're together, so you should have an interest in this property, a beneficial
Okay.
interest in this property.
Yeah.
Then, so that's the common intention bit. Then the constructive trust arises if there's been what we call detrimental reliance. So you
Okay.
do something on the basis of that, the common intention. Okay.
Okay.
So that could be that you put money towards the property, you invest in the
Hmm.
property, you do stuff to the property around the house. But this is all done on the basis that you are effectively you're contributing and doing things because you've agreed between yourselves that you've got this common intention to
Yeah.
have an interest in the property.
Okay.
Now, as you can probably tell from that, within a relationship, relationships are quite informal things. These
Hmm.
kind of serious discussions often will just have a few conversations about it. It won't necessarily
Yeah.
be written down, and you may act on those conversations and assurances and things like that and do what you thought you were going to do. And then at the end of the relationship, when you're not in a
Yeah.
good place, the other person says, well, it's my house, so you need to get out.
Yeah. Yeah.
Now, the difficulty with any of these types of claims is the evidential one,
Yeah.
because what you're trying to persuade often a court in these circumstances is, look, because I've done these various things, there was this agreement between us, and the other person saying, no, there wasn't, and you're saying, yes, there was. And
Yeah.
you're looking potentially at the whole course of dealings between a couple of, a relationship that could have gone on for years.
Yeah,
It
for
could
sure.
it could have gone through a series of houses. People
Yeah.
move up and move together as they go through, and people do different things financially because of the circumstances at the time. So they may have co-owned a property at one stage, then sold that, and it's ended up in the ownership of one person at another point because of life decisions.
Yeah.
And so, as you can tell, it's sometimes can be incredibly complex to unpick.
Yeah.
So what you start off with in these circumstances is that there is absolutely the opportunity and the chance to assert a claim in a property at the end of
Yeah.
a relationship, but some of those claims are easier than others
They're
because
harder to, it's hard to prove those contributions because, I mean, there's some that are, I guess, easier to evidence, like paying
yeah,
towards the mortgage, but
yes,
then doing home improvements, those kind of less quantifiable and visible things could be really hard
yeah.
to evidence.
Well, yeah, it's who keeps receipts from a decade ago, and
10
even
years
if you
ago,
do,
exactly.
yeah, and even if you do keep the receipts, do they still actually can you still actually read them or make sense of them?
Yeah, yeah.
And when you're doing building works, builders like payment in cash and this kind of stuff, and there's
Mhm.
all sorts of things that go on that make the evidential trail quite difficult and complex.
Yeah,
The cases become easier if you have more contemporaneous evidence of what
yeah,
went on. If you do have emails, if you can point to these things, but
yeah.
they are difficult claims to run, definitely.
And so is the safest way of asserting a certain claim on the property to contribute to the mortgage? Is that one of the easiest things to build towards?
So it can be. I think the issue often is that contributions to the mortgage aren't necessarily done on that kind of set basis, and
Okay.
you can look at a mortgage in two ways. You can look at it as being sort of a capital repayment element, but what if
Yeah,
it's an interest only mortgage, or it's a
that's
large
true.
proportion of that capital
Yeah,
is interest? What are you actually contributing to the capital in the property, to that beneficial interest that you might
yeah,
be contesting? So absolutely, it could be a very good indication of, well, why would I have been contributing to the mortgage unless I had an interest in the property?
yeah,
And then the counter argument to that is sometimes, well, if you're renting a property, you'd be paying towards the outgoings, and the mortgage is just one of those
yeah,
outgoings. And so
yeah,
all the time, you have evidence that you can build up and that you can put towards, and because the court would be looking at the whole course of dealings, some of this stuff can be really persuasive and can
yeah,
can really help your claim. But
yeah.
it's not necessarily going to be determinative, and it's not as simple as saying, well, I've contributed to the mortgage, so I should get my mortgage repayments back.
Yeah. And the challenge is often showing that those contributions were for the mortgage. Because a lot of times people divide and conquer. So, they'll say, well, this is your house, it's your mortgage. You pay the mortgage, I'll pay all the bills, for example.
Yes.
And in their
Yeah.
head, it is a way of paying for the mortgage because they're covering the integrity of the rest of the expenses. So does that actually make people quite vulnerable if they have those kind of arrangements?
It does. I would say you're already vulnerable anyway
Mm.
if your name isn't on the deeds, and if you don't
Yeah,
have some form of written agreement in place.
yeah,
But certainly, if you're having that kind of offset type of arrangement where you're meeting some things and the other person is actually meeting the specific costs in relation to a property,
yeah.
then yes, you're even more vulnerable. There's also the curse of the joint account, because
Ah, yeah,
you can imagine that people have a joint account. They put amounts in. One person puts some in. One person puts more in. Person puts less in. Sometimes they do it equally. Sometimes they don't.
mm,
Sometimes they use it for holidays and living expenses. Sometimes they use it for the house, and that means it's very, very difficult to unpick and say, well, that amount has gone towards the mortgage,
yeah.
and
Who was it who paid that invoice, really? Yeah,
exactly. And that's the thing, because if you're not on the title to the property, you're unlikely to also be on the mortgage, because
yeah, yeah,
mortgage providers don't like people being on mortgages unless they're on the title as well, and vice
yeah,
versa. So again, it becomes this sort of evidential burden, and sometimes there is this difficulty and there is this argument that could be run to say, this is just contribution to life, this isn't
yeah,
contribution to the house. And so the bits, I think, is being very, very aware when you are
yeah,
moving into a position like this, that there is a vulnerability there, that there is a position where you could be contributing significant amounts to a relationship which won't secure you any
yeah.
definitive right in relation to any form of property. And
I've
so
definitely had clients in that situation. It's absolutely heartbreaking because they felt that they were contributing towards this joint asset, but
yeah.
they were spending money on bills, so it's just gone. And the other person was accruing wealth through paying off the mortgage.
Well, absolutely, and you also get in longer term relationships as well. And I've had some very distressing cases where you have, and it is often older women who have gone through a relationship. They've had the children. They've
Yeah,
made sacrifices in their career and their life in order to support the family, work, not going out to work and looking after the family. And then
yeah.
they come to the end of that. The children have grown up and left the home, and they have absolutely no claims. They've not got pensions built up because they haven't been
Oh,
working,
goodness.
and
Yeah.
they are totally reliant on the other person actually going, look, morally, I
Yes.
should account to you for this.
Yeah, yeah.
And very, very sadly, it's the rare case where the morals reflect a monetary agreement.
Yeah,
It
usually
does happen.
people are not in the best of terms at that stage, unfortunately.
exactly.
Of course, in an ideal world, people anticipate this and they document everything properly and they have all their ducks in a row. But
Mm.
for those who realize too late, what can
Yes.
they do if they want their share to be recognized formally?
So I think the first thing is sometimes a little bit of it might feel a bit sneaky, but a little bit of pre planning
Yeah,
before you. If you know, sometimes relationships end and they end because of very serious reasons, and you should never
yeah,
delay ending a relationship for financial reasons.
I
Is
agree.
certainly my view. But sometimes it's just the case that you're not getting on with the other person, that things are starting to fizzle out, and it's just that you're not hugely happy, but you don't really want to be in that relationship anymore.
Yeah,
And when there's no kind of danger to you, then actually, why not actually think financially? What will this look like if actually this all comes to an end now?
yeah,
And that's the point where you maybe think about taking some legal advice about it. But
mhm,
practically speaking, it's starting to get your ducks in a row as to potentially finding out what claims that you have
yeah,
and starting to marshal the evidence. It's one of those things. It's going to become quite it's going to become quite obvious, isn't it, if you're speaking to your other half and going, "Oh yeah, by the way," what,
it could be a bit obvious indeed.
remember that interest, and then sort of putting your phone underneath their nose for them to say, remember that interest in the house. So that might be a bit much, but certainly there's sometimes when relationships break down, it can be difficult to get information, to gather things,
Yeah, that's true.
gather that evidence, and obviously you're not entitled to sort of rifle through drawers and do all of this kind of stuff.
Hmm.
But there's no harm in you finding out what the situation is in.
Yeah,
If they're willing to share that, if your spouse is willing to share the information with you, finding out what that information is.
yeah,
So there's no harm in a bit of pre-planning and a bit of a pre-thought about that.
yeah,
um, and I think it's also, there is still that opportunity within the whilst the relationship is still going, or even with a separation that's done in a sensible way, or in a sort of a more
yeah,
consensual way, to start having those conversations early, and trying to make the most of the fact that you have been in a relationship for a long period of
yeah.
time.
And it should be honored. I agree. So that, really these kind of cases, with the law being really not up to scratch with regards to the reality on the ground, it sounds like you looking at mediation or any out of court resolution is probably the best approach, because then you can have a much more human conversation about the reality of everyone's needs.
Absolutely, because actually, when it comes to this, there is the legal position,
Mhm.
which you may have a strong case, you may not have a strong
Yeah.
case, but whatever your case, if the other person is going to contest that, it's going to take a lot of time and a lot of costs to go through,
Yes.
and
Yeah.
then you want to avoid that if you can. And so absolutely, any form of sort of mediation or ways that you can have those conversations in a supported and safe environment is definitely
Yeah.
a good opportunity. Aside from anything else, what it also does is it flushes out what the other person's approach is going to be, and that can
Yes.
be really useful. That
I
can actually
agree.
be really useful, to find out what they're going to say about these things. Because often I will speak to clients and they have a lot of fear about what the situation will be and what the other person
Yeah.
will do, but they actually don't know, because
Yeah.
they don't feel they can talk to them about it because of the
Mhm.
situation they're in. Now, moving it to mediation is a way that you can have those conversations in a safe environment.
Yeah.
It's important to make sure that you pick the right mediator, and one who
Agreed.
has some knowledge in relation to these types of claims, because
Yeah.
they are complex legally, and you can be steered down the wrong route if they don't have experience in those
Yeah.
types
I
of
could see
claims.
that.
But there are not millions, but there are a lot of brilliant mediators out there
Yeah.
who are absolutely great in these types of situations. And I've had lots of cases where people have feared the worst, but actually they've been able to end up with a never the best result, because mediation is never about the best. It's always about getting the good result, or the okay
Yeah.
result that people can be satisfied with, but that end up with positive results for clients.
Yeah. I mean, it sounds like for the person who is on, kind of the underdog in that relationship, there is definitely an advantage in having the conversation, because that's where they will have the most chance of coming up with something that actually at least satisfies some of their needs.
Exactly, and it's that thing of, why not try it?
Yeah.
Because what's the worst that can happen? The worst that will happen is you won't reach an agreement, but you still have protected your position. If you were ever to have to go to court about these things. And it's far more cost effective to try and get things settled and documented and sorted in that way if you possibly can. I freely acknowledge that it's not always possible, and often separation comes because people can't have those conversations and can't do those things. And so
that's true as well.
There are, as I say, there are opportunities for people to run claims, whether you're on the title deeds, whether you have a beneficial interest that's sort of defined. Sometimes you can challenge what that is because of what's happened during the relationship. And so, say for example that you owned a property and it was in joint names, but there was nobody was quite sure who actually owned what in terms of the beneficial interest. There are claims that are that can be taken along the similar lines of the common intention constructive trust to actually push for a different outcome on that basis as well, and to start to take into account maybe things like contributions to works to the property, mortgage payments and that side of things. It's all about establishing that beneficial interest, because that can then sometimes lead to you being able to bring in other sorts of claims as well that relate to the property too.
And if you're the one who's trying to fight for that beneficial interest and you manage to prove it, whether it's at court or you convince the other person, what would be the solution? In most cases, I assume the house gets sold or the other person has to buy you out. Is that how it typically works?
Yes. So the way that the law is set up is it's quite sort of straightforward from the court's perspective, because if you're ever in court proceedings, the court has the power under the legislation to declare who owns what when it comes to the property. So you get a declaration as to what your beneficial interest is, and then the court has a power to order sale of the property as well. Now, strictly speaking, there isn't a power for the court to order one of you to buy the other out. There is case law out there which suggests that if it's within the contemplation of the trust for the property that one person can buy the other person out, then the court can order that, because they're merely stepping into the shoes of the legal owners to decide what should happen to the beneficial interest. But most of the time, the outcome at court is going to be order for sale and division of the proceeds.
The easiest way to liquidate.
It often is, but there's sometimes is that situation where maybe you do want to try and retain the house. And so sometimes you can persuade the court that maybe that you can match offers that are made on the open market and all of those kind of things. So there are lots of sort of mechanisms that can be put in. Sometimes it will take a property a long time to sell. And so you might want some fallbacks in terms of maybe a property going to auction rather than being sold on the open market. So there are sort of nuances and bits and bobs that can happen if you go through that court process. And it's another benefit to trying to settle things outside of court is that you have far more flexibility.
Much more original and creative solutions as well.
Exactly. And you can factor in time frames, and you can factor in, for example, people staying in the house for a particular period of time to ensure they can move on. And so, there's a much greater level of flexibility than the court can provide in these circumstances. Another good reason for trying to get it sorted.
But I guess a source of concern for the person who is on the deeds, they can technically their name could be replaced on the deeds if the court decided that was the right way to proceed.
Yeah, well, it wouldn't necessarily be the case that they would assume legal ownership. So it would be on the title, but there would be a confirmation of a beneficial interest in that property, which would mean that if it was ever sold, they would need to account to them for those proceeds. And as I say, if you're wrapped up in the court proceedings, you're going to usually end up with an order for sale. So it will all be dealt with as per that order, unless what sometimes happens is you go all the way through, you get an order, and the other side says, well, why don't I just buy you out? And then what happens anyway. So you kind of get there in the end after 18 months and an awful lot of costs.
There's a lot of money and time that wasted, really.
Absolutely.
And so you mentioned earlier that most banks don't like to give a joint mortgage when there's only one name on the deed. But that insinuates that some of them do. Does it make a difference if it's a joint mortgage? Does that in any way help with the case?
Well, as I say, it would be an unusual circumstance to have a solely owned property with a joint mortgage on it. But I don't see why it couldn't arise in specific circumstances, because it's all about the bank or the mortgage provider being able to recoup its its mortgage
Yeah.
effectively. Again, though, it would be one of those things of why on earth would you be on a mortgage unless you had an interest in a property? It would be
Yes,
that
that doesn't sound like a good proposition.
exactly.
But
And also,
some people might think it's an easier thing to do than, updating the deeds, for example.
absolutely. And I mean, I suppose the other thing to think about as well is that the banks are much, much hotter than they ever were in terms of making sure people get independent advice and that forms are signed in relation to an interest in a property. So often you will find, and they have this often with maybe with Bank of Mum and Dad, where they're trying to help children buy a property.
Yeah.
Well, where they're gifting significant sums of money, and the mortgage provider makes them sign a document which says you have no interest in this property, it's a gift.
Yeah.
And that will often be the case with these types of arrangements, that there will be some form of writing, some kind of form or document or deed that's been signed which says they don't have an interest. And so sometimes actually by going down this more formal route and maybe going on a mortgage or being a guarantor or anything, that can count against you having an interest in the house, because the kind of the steps that you've taken can actually mean that there's stuff on record there where you've signed and said, no, I don't have an interest in the property.
Yeah.
And some of the contests that you have in court are about the fact that people feel a little bit more comfortable sometimes in saying one thing to mortgage providers and then saying other things to their family.
Yeah, of course.
Which is obviously the wrong thing to do, but it does happen.
Yeah. And you raise a good point there around loans, because a lot, it's very common that mom and dad will lend money towards a deposit or something. And so at the time of separation, who's shared is that considered? Is it part of the person whose parents contributed? Is it considered a shared gift? How does it get treated?
Well, and again, you can have arguments about this, because often when you're in a relationship, when you receive the gift, you treat it as being a gift to you both.
Yeah.
Now, is there the documentation to actually back that up, or is there effectively an idea that it's a gift to the person, to the child of the parents? And again, that can be argued about. So again, it's about gathering your evidence about that. And I think in some ways, in this day and age, it's helpful that we have emails and we have WhatsApps and we have text.
I can retain all that.
Exactly. And so there is often a record of what's going on that can back up what's happening. But sometimes even those WhatsApps and texts aren't as clear as maybe we would like evidentially. Because to be honest with you, when you're in a relationship and when you're in that environment, there's an awful lot of trust happening.
Of course. And you don't feel like you have to document everything.
Exactly. And there's an awful lot of stuff that's left unsaid, I think, within relationships sometimes. And sometimes it's also thought that maybe it's not sort of counter to being in a trusting relationship to have these discussions. Whereas my view is it should absolutely be the opposite. Surely it shows absolute trust if you can be transparent and open about financial matters. And if you have these conversations, that's got to be a better underpinning to your relationship than keep lots of things separate.
Pretending. Absolutely.
It never happens. Yeah.
But so the default would be, though, that the money given by the parents would be aligned to the person, the child of that couple. Would that be the default position?
Yeah, I think that's going to be your starting point, and so you're going to want to find your evidence to show that it's different to that. So, for example, maybe there can be sort of subtle sort of indications of that. If, say, for example, it's transferred to a joint account rather than to a sole account, or sometimes even it's transferred to the person who's not the son or daughter of
that's
the
true.
parents. So so suddenly you can start to build this picture, but that as again it is part of this evidential matrix that you put together in support of claims at court.
Okay, so you're going to want to have to show all of those circumstances and evidence the context for the loan or the gift.
Absolutely, and it's really interesting for lawyers to pick through these things and to analyse and to put these arguments forward, but it's an awful lot of work. And there's an awful lot of work for the person to put their case forward. And sometimes as well, there are these situations where there is nothing. It's all done by word of mouth. It all just happens. People sign forms. People have had this understanding. Sometimes it can just be as much as one person's word against the other in these things. And in those circumstances, it's going to be, if you're in front of a judge, it's going to be who the judge places their belief in who they think is telling the truth in these circumstances. So that can be, how good a witness are you?
Yes, absolutely. There's a Russian roulette of the court system, really.
Absolutely. It's the absolute risk of litigation, is that you can think that you have a very good case, but it will come down to the hearing on the day and how it's presented to the judge, and that there is a bit of a roulette to do with that, as however much you prepare.
Yeah, absolutely. So before we part ways, could you just, I guess, kind of bring down everything you've shared into your top 3 tips to someone who has been cohabitating, is now splitting up, and their name is not on the deeds? What would you recommend they do?
I think it's that thing of starting to think about what life is going to look like separated, and to start to have that conversation with the other half, if that's possible to do. I think, as is always the case, another top tip is to get early legal advice in those circumstances. It's better to know what's in front of you, and as we've kind of sort of explored a bit, these things are so fact specific that actually getting some advice and knowing where you are, and it will really help you have those conversations and those thought processes. I think the other thing to think about as well is there could be other things that you can do to sort of protect your occupation within the property. There could be things that you can do to sort of make sure that everybody's going to be in a sort of a safe and sensible position to have these discussions. So again, that's part of the early legal advice discussions as well, depending on how the relationship is coming to an end. I think the other thing to think about is, actually, during the relationship, even if we're not at this point of separation, should you be thinking during the relationship, should we be doing something to change this? Should we think about doing a cohabitation agreement? It's never too late. It's never too late to do a declaration of trust. Those big life events that happen, children being born, people doing up houses, people, getting doing the massive investment into the amazing kitchen that you're putting on into the property. Use those as triggers to have that conversation, because if you weren't in a relationship with them, if this was some kind of business type arrangement, you're not going to be paying somebody 30, 40, 50,000 pounds to do something to a house without at least working out what that means for you. Why should it be any different for you in these circumstances? Because that it's all great when you're in love and it's all going well, but when it's not, these aren't the conversations that you're going to be able to have. People's memory is valuable.
And you're much better off having those conversations when everybody's amenable and trying to be considerate towards each other, than at a time of crisis where there's potentially resentment involved.
Absolutely.
So what I'm hearing is, across all of your tips, is the earlier the better. Try and gather facts, gather evidence, try and get the right advice as soon as possible, so that you can try and mitigate the risks, really.
Absolutely, because what you have to remember is written evidence is from a court's perspective, written evidence is the best, but contemporaneous evidence is also great. So even if you're having conversations at the time, you would, the idea of maybe sort of sending yourself an email at the time, say, we chatted about this today, and have that effectively being a time-stamped kind of document. All of these kind of things might help if you don't feel open to having some of these conversations.
Yes, so it's good to know about them.
Because the other thing as well, just to think about really briefly, is that when people do separate, during that separation process, there are ups and downs.
Yes.
And oftentimes people will talk about these things in a particular way, and there have been a slew of recent cases where people have basically been talking about ownership of property, and potentially people taking the property, or they're not interested in having an interest in the property anymore, all of these kind of things. Now, if those conversations have been documented a bit better, those cases would probably have been a little simpler to run.
Okay.
So trying to keep records of those conversations and trying to do those in a safe environment where actually that they can be looked at in the right way and brought to the court's attention. That's something to think about as well.
Great tip. Thank you so much, Richard. Thank you for sharing all this information. I will put your contact details in the episode notes, so if anybody wants to reach out to you, they can do so directly. But thank you for everything you've shared with us today and for answering my many questions. It was a great conversation. Thanks so much.
Thank you very much as well.